Hey everybody, it's Andy, and welcome back to my office in Modesto, California. I'm an attorney licensed to practice law in California as well as New York, and today I'm actually going to go over an aspect of New York law for once. So just to kind of clarify, I suppose, so I'm licensed to practice law as an attorney in California and New York State. I generally don't take cases in New York, however. And the reason is because I don't, certainly, at least not at this point in time, I don't maintain a physical office in New York State. In New York, unfortunately, or fortunately, depending on your perspective, I guess, has a statute, Section 470 of the judiciary law out there, has a statute section that basically says that even if you're an attorney licensed to practice law in the state of New York, if you don't have an office physically in the state somewhere, you can't take clients. So at this point in time, I don't have an office in New York State at all. In the future, if you're watching this video kind of way off in the future, check my website. I'll link it down below. And see that maybe at that point in time, I guess I might have an office in New York State, I might not. So hopefully that made sense. New York law just unfortunately is that way. So I don't take clients in New York. However, if you do need a referral and stuff, I do know quite a few attorneys out in New York State. So if you need a referral and I can do that, I'm happy to do that for you. All right. So all that kind of preamble stuff out of the way, what I'm going to talk about today is the residency requirement that New York State has for a divorce. So a while back, and by a while back I mean 4 years ago, so like in 2016-ish, I put out a video that goes over this same residency requirement except for California. I'm going to try to link that video kind of up here somewhere. But I was watching that video kind of randomly, a few weeks back. And I noticed in that video that I actually said, oh yeah, hey, I'll record an analogous video for New York also. I'm assuming that at the time I meant to record this video sooner than that, but apparently, sooner in my mind means 4 years. So kind of surprised to kind of see that I let this video slide that long. Anyway. So the residency requirement idea, kind of in general, I suppose, is that in order to file for a divorce in a state, in any given state in the U.S., generally speaking, you're going to need to satisfy a certain set of criteria, whatever that state happens to set them as. So in California, you can't just move to California and immediately file a divorce. Same idea, you can't move to New York and immediately file for a divorce in New York State. And I haven't checked every state in the U.S., but I would imagine that, for a variety of political reasons, morals reasons, public relations reasons, no state wants to be known as a divorce capital, like, for easy divorces. It makes sense. You don't really have to kind of think about it too hard. So the way that states basically kind of address that problem is to go like, okay, if you want to move to our state, you can. If you want to file for divorce here, you can. Fine, we understand that's inevitable. Certain people will always get divorced, but you have to satisfy these criteria first. California has its own criteria. I went over them in that video kind of up here, and New York has its own criteria also. So in this video, that's what I'm going to go over. The relevant statute here is going to be Section 230 of the New York Domestic Relations Law. So New York Domestic Relations Law, Section 230, which I'll write over here as well as paste and link down below for you. So if you read that statute, it's actually not hugely complicated. It's a little confusing because there's various ways in which the residency requirements can be satisfied. California has a really simple residency requirement. New York's is more complicated. But anyway, let's see if I can explain it properly. So basically, there's going to be three options for you if you want to file for a divorce in New York. Option one, I think would probably be the easiest option, is either spouse has to have lived in New York State for the 2 years immediately preceding filing of the divorce case. So basically lived in New York State for at least 2 years, for either spouse. If you satisfy that, then you guys can file for divorce in New York State. Option two, a little more confusing, is basically either party has lived in New York State for at least 1 year, for at least a year preceding filing of the case, and one of these three over here is true. Number one is you guys got married in New York State. Way back when you got married, it was in New York, not somewhere else. Number two is that you guys have lived in New York State as a married couple at some point. So either of these two, or either of these three actually. So you guys got married in New York. You guys basically lived in New York State somewhere as a married couple, And number 3 is that the grounds for divorce arose in New York State also. So, got married in New York State, lived in New York State as a married couple, or the grounds for divorce arose in New York State. Any one of these 3, plus, basically living in New York State for a year. If that is satisfied, then you guys can file for divorce in New York State also. So a little bit about grounds. I'm not going to go over grounds for divorce in New York State in this video. I think I'm going to do that in a subsequent video. But grounds basically refers to the reason, the bases, the grounds, for lack of a better word. There are certain grounds upon which you have to file for a divorce in New York State. You can't just do anything as a reason. But the grounds, whatever they are, have to have arisen in New York if you want to use option 3 that I described earlier. So hopefully that made sense. And the final option over here basically is going to be that both parties will live in New York State on the day the divorce case starts, and the grounds for divorce, whatever they are, the grounds for divorce arose in New York State. Complicated to say. So hopefully that kind of makes sense for everybody. So 3 options. Number 1 is that either party has lived in New York State for at least 2 years preceding filing of the case. Number 2 is that you've lived in New York State for at least a year, and one of these 3 is true. You guys got married in New York State. You guys lived in New York State as a married couple, and the grounds, or the grounds for divorce arose in New York State somewhere. If any of these 3 are true, and you guys have lived in New York State for a year, then you can file for divorce also. And the last option, option 3 over here, is basically going to be that the grounds for divorce arose in New York State, and both parties live in New York State on the day that the divorce starts. So that's New York Domestic Relations Law Section 230. And I'll link it down below for you guys. So hopefully that helped. As you can probably see, this is actually more complicated than the California version, the California analog of this video. But like I said, each state sets their own criteria. So hopefully that helped, and go ahead and share, comment, like, subscribe, and I'll talk to you guys next time. Remember, however, that because of Section 470 of the judiciary law in New York State, I don't take clients in New York State at this point. Feel free to get in touch, though. If I can make a referral, I'm happy to do that. All right? Talk to you guys next time. Thanks.